the defendant was attempting to shoot at someone else, and I was the one who ended up being shot.
She has not shown one bit of remorse or concern for the man she shot instead of the ones that she wanted to shoot.
I don't think I've ever heard someone care as little as she does about what she did.
And to Daniel, I am very, very glad that he is well after a difficult time he has been through. And I truly hope that he has a great future, and I wish him nothing but the best in his future.
Please, Your Honor, give her the maximum sentence so she can never harm another person.
Hello everyone and welcome back to the court bench. I want you guys to imagine going to a New Year's Eve party, minding your own business and ending up with a bullet in your stomach, only to have the shooter who shot you on accident complain in court that you are ruining her life. Well, that's exactly what happened to 29-year-old Daniel Johnson. On January 1st, 2024, Olivia Clendenin became enraged after seeing her estranged husband and her new boyfriend hanging out together. And just like any crazy woman would do, she left the party, grabbed a gun, drove her mother's Jeep back to the house, firing a volley of shots into the crowd. One of those bullets struck Daniel, who is an innocent bystander, completely destroying his intestines. And incredibly, she thinks she's the victim. And her attempt at an apology is one of the worst attempts that I've ever seen anybody make to try to apologize for shooting somebody, which you guys will see at the end of this clip. But let's go ahead and jump in here, where the victim's lawyer is going to be playing an audio recording where the defendant is talking to her family as this case is going on, basically showing zero remorse as she's being tried. So let's jump in.
Yeah, he was crying.
Yeah. I mean, you're ruining a young girl's life. How could you not be upset?
You're ruining a young girl's life. How could you not be upset? That's her reaction to the verdict. She sat here and listened to Daniel Johnson testify, listened to her mother. She knows what she did. And her response to all of that is that the victim, because he participated in the prosecution in this case, is ruining a young girl's life. And I'll tell you, Judge, I've listened to almost all the calls she's made since sentencing, and that attitude is the attitude she's had throughout the entire process. Depending on how you calculate this, the minimum sentence that she faces is either 11 or 14 years, depending on the way you look at the specifications. And I would just say, Judge, I would argue to you that for the defendant to receive a minimum sentence in this case would demean the seriousness of the case. I think that a sentence of 11 or 14 years would not be appropriate knowing the nature of the case we have. I don't think I've ever heard someone care as little as she does about what she did. So, Judge, I would ask you now to allow the victims to speak to you as well.
All right, thank you.
Hi, my name is Sharon. Daniel is my grandson, and he's my heart. He's not a perfect person, but he has a good heart. He would never think of hurting somebody else. He used to be a true go-getter. He had good grades throughout school. He played football, and he excelled at it. He has many friends, and I have never met anyone who didn't like him. He used to go to the gym regularly and run miles every other day. But because of one person's rage that she admitted to feeling, nothing is the same, and I don't think it ever will be. His left side hurts constantly. He suffers from severe stomach problems because the bullet that hit his rib exploded and destroyed his intestines. And I mean destroyed. He still has several fragments of that bullet in his body, which will likely cause even more problems as he ages and those begin to move. The saddest part of all of this is that throughout the entire ordeal, she has not shown one bit of remorse or concern for the man she shot instead of the ones that she wanted to shoot. She continues to look at Daniel as if he has something to do with it, as if he would drop charges when it was the state, not Daniel, that brought the charges. Your Honor, I also want to emphasize that she was convicted of attempted murder. That's not just a mistake. That's a deliberate act. And I believe with my whole heart that if she is ever enraged again, as she described it, she will do the same thing again. Please, Your Honor, give her the maximum sentence so she can never harm another person. She may have already given Daniel a life sentence with what she did to him. So there's no amount of time you could give her to actually satisfy me. But I ask you to protect others by ensuring that this doesn't happen again because of her anger. Thank you, Your Honor.
Alright, awesome. So this is actually a very great point by the grandmother. Olivia was convicted of attempted murder. Now, you might be thinking, wait, she was trying to shoot her husband, not Daniel. How is that attempted murder against Daniel? Well, it's because of a wild legal concept called transferred intent. If you point a gun intending to kill person A, but your aim is terrible and you hit person B, the law simply transfers your murderous intent over to person B. So that is why Olivia is being charged with attempted murder, and the grandmother cleverly decides to loop that into her testimony just to add a reminder to the court that she is being tried for attempted murder.
Your Honor, my name is Daniel Johnson, and I'm here to give some insight on how this crime has affected my life. On the day of the incident, I was attending a New Year's Day get-together. I had been invited over and was sitting on the porch minding my business. The defendant was attempting to shoot at someone else, and I was the one who ended up being shot. In that moment, my life changed for reasons that had nothing to do with me. Since that day, I've had to live with the physical and emotional damage. I was shot in the stomach. I had multiple surgeries. My recovery has not been simple, and it hasn't ended. I deal with chronic pain on a daily basis, along with ongoing digestive issues that have forced me to completely change how I take care of myself and eat. Mentally and emotionally, I've been dealing with PTSD. What happened that day didn't just end when the incident was over, it has stayed with me. There is a level of stress, fear, and anxiety that I now carry that I didn't before. What makes it especially hard is knowing that I was completely uninvolved. I was simply in the wrong place at the wrong time, and I'm the one who will have to live with the ramifications. Olivia has not shown any level of respect to myself or my family. I have not received an apology in any form or fashion. I do not hate her or have any evil feelings in my heart towards her or anyone associated with her, for that matter. I truly am just sad, and I wish that things were different and this would have never happened. Thank you, Your Honor.
Thank you, sir.
As it relates to the allied offenses, it is our position that the discharge of a firearm is, in fact, or we would ask Your Honor to find that it is an allied offense of the attempted murder count, in light of the fact that under what the state has presented in their sentencing memorandum in the case law, you are to look at the conduct of the defendant in determining the position on the allied offenses. As it relates to conduct, from what was presented at the trial, there were at least 2 shots that were fired off in quick succession. The conduct as a whole and the fact specifics where there is some type of a heated argument that has occurred and shots that are fired off in quick succession pursuant to State v. Johnson, that all of that taken can mean, of course, that there would be allied offenses. So as it relates to the other victims, certainly the intention was not to harm anybody inside of the home. This was not something where there was a shot and then shortly thereafter there was a break in another shot that would have hit some surrounding property. Everything happened all in quick succession, all the same course of conduct. And so we would be asking that it be an allied offense. It's easy to cherry pick a call and indicate that there's a lack of remorse. I think what is relevant to Ms. Clendenin is actually what was presented during trial, during her interview with the officers. And as soon as she found out that Mr. Johnson was hit, her actual reaction was, "Oh my God, is he okay?" And she was inquiring of the detective as to his status. Now, over time, people can view things differently, the impact that it has on themselves instead of looking outside of themselves. Also, my understanding, though I don't have any jail calls to play for, Your Honor, specifically, that Ms. Clendenin did speak with her family about sorry, not to say sorry, I don't want to put words in their mouth, but feeling a certain way, that it's unfortunate that Mr. Johnson and his family have had to experience this. That is my understanding of some of the conversations, certainly not all of them. Clendenin's mother appeared to be indicating she was expecting somebody to be jumping up and down, joyous and, excited, so to speak. But Ms. Clendenin indicated, well, that's not what they were doing. And here's maybe why they weren't doing that, because this is not only impacting them, but it also impacts me in my life. So, again, I don't know that it's appropriate to pick and choose the limited phone calls to not include everything. But of course, that was the state's decision and within their right to do that. I'm by no means trying to say that the serious provocation on his part by any means, but I think the actual intended individuals, according to what was at trial, were the other two gentlemen, and there was some inducement or facilitating in terms of bringing upon the offense. So in terms of the mitigating information, Ms. Clendenin, as your honor is aware, has remained out on bond during the pendency of this case, which was over a year, without any violations. She was an upstanding member of her community leading up to this. As part of her ownership of the dance studio, she would actually give out scholarships to kids in need. By that, it wasn't something where the studio actually gave money, but she would donate extra time, extra lessons. It's my understanding that Ms. Clendenin, also leading up to this, was attending Northern Kentucky University, so she was trying to improve her life and her standing in life. She'd recently completed a business correspondence course through Harvard University. She held a number of jobs during the course of this case and leading up to it. We again would ask your honor to impose a sentence of 8 years as it relates to the firearm specifications, that your honor would merge the discharge into a habitation with the attempted murder, and we are asking the court to impose a minimum sentence at this time. We appreciate the court's time and consideration.
All right, awesome. So we pretty much just heard the defendant's lawyer's final statement. So let me go ahead and translate a lot of what she said into more normal terms for you guys. The defense attorney is arguing for pretty much what's called allied offenses of similar import, which under Ohio Revised Code 2941.25 basically states if a defendant commits multiple crimes with the exact same conduct and a single intent, like firing a gun into a house which also hits a person, the defense wants those charges to merge into one single conviction. Pretty much so she only serves time for one crime instead of getting stacked consecutive sentences. However, it is pretty rare that judges actually buy this when multiple distinct harms occur. Which, to be honest, the defense attorney is really just trying to do her best with the cards she has on the table, which is it's not a good hand. However, now we're going to get into the honestly most insane clip of this entire case, where we're going to actually have the defendant give her final testimony as well, which I'm not even going to say too much. Let's just go into it.
All right, thank you.
Your Honor, I respect this court and where it stands. I would just like to say that I care deeply about my family, my friends, my business, and those who rely on me in this world. I take great pride in the impact that I have had on my community and the children that I coach, and that I basically raise them with their parents. And I will continue to do so moving forward. And to Daniel, I am very, very glad that he is well after a difficult time he has been through. And I truly hope that he has a great future, and I wish him nothing but the best in his future. Thank you.
Okay, I have to jump in here because this has to be one of the most tone-deaf allocutions in courtroom history. I think, and I probably am very wrong, but this was what I think is called an attempted apology, I think. But being very honest with you guys, this might be the worst attempt at an apology I have ever seen across this channel. If you guys don't know, an allocution is a defendant's formal opportunity to address the judge and show genuine, heartfelt remorse before the sentence is handed down. But instead of a tearful apology or maybe taking some real accountability, she starts listing her community service resume and talks to the man whose intestines she destroyed as if she's casually signing his high school yearbook. Like, it's honestly insane. I'm laughing just, reviewing this clip for you guys. I don't know. I mean, she'd even say the word sorry a single time in, I guess, her attempted apology. Was that even I don't even know if it was an apology. Let me know what you guys think. But let's go ahead and jump back in here into the final part of this case where the sentencing is going to be handed down and see what she's going to serve.
All right, thank you. I've considered the purposes and principles of sentencing, including punishment, deterrence, and protection of the public. The Supreme Court's decision in State v. Beatty, the court finds that it must impose 2 of the firearm specifications, the 5-year drive-by shooting specification and the 3-year firearm specifications. I do not believe that count 4 merges with count 1. The sentence on count 1 is 8 to 12 years to be served after the 5 and 3, and the sentence on count 4 is 2 years, but that will be run concurrent with count 1 for a total of 16 to 18 and a half years. On release, you will be supervised by the Adult Parole Authority for a period of 5 years. If you violate any of the rules of supervision, the Adult Parole Authority can send you back for 9 months per violation, up to 1/2 of your stated sentence, which would be 8 additional years they could add for cumulative violations of post-release control. It is rebuttably presumed that you will be released from service of the sentence after serving the 16 years. The Department of Corrections, however, may rebut the presumption if, at a hearing, the department makes specific determinations regarding your conduct while confined, your rehabilitation, your threat to society. If you've not been released prior to the expiration of the 18 and a half years imposed as a part of the sentence, you must be released upon the expiration of that term.
And drop the hammer he did. After this incredibly tone-deaf display, the Warren County judge officially sentenced Olivia to between 16 and 20 and a half years in prison for attempted murder, felonious assault, and discharging a firearm into habitation. The prosecutor even noted the irony that while she started out free on bond, she will spend the rest of 2026 and at least the next decade and a half locked up. As of now, Daniel Johnson continues to recover from his severe injuries, but justice was absolutely served. I would love to hear your guys' thoughts on what you thought of her so-called apology in the comments below, and I'd appreciate if you guys can give us a like and subscribe. We're very close to our first 1,000 subscribers, and we'll see you guys in the next one.